You've got systems, spreadsheets, a 5-year strategy, but here's what you don't have as a business owner. A plan for what happens to your business and your family if something happens to you tomorrow. Will your team be able to access business accounts? Will they be able to operate without you? Will your spouse have access to all of the business assets and be able to liquidate them seamlessly? Because in Colorado, if you don't have an estate plan, it can unravel in a pretty negative way. This video is for you, business owners, entrepreneurs, single member LLCs, partnerships. If you own a small family business, then listen up. We're going to talk through exactly what happens if you don't plan for your business, and also about what happens if you do plan and how you can avoid costly mistakes by planning ahead. Here's the legal reality. In Colorado, when a business owner dies, the business becomes part of the probate assets. They're considered to be non-liquid assets, and the business becomes part of your probate estate. If you didn't have a will, then it becomes a nightmare for the personal representative to figure out where your business should go under the laws of intestate succession, which is basically what happens if somebody dies without a will. Once the business becomes part of your probate estate, everything is frozen, nobody has access to any accounts, and the personal representative that gets appointed by the court will have to take the business through probate. If you do have a will, the business will still have to go through probate. The easier part will be that your will actually direct where it'll go after the probate process is finished. During this whole time, no one can legally authorize anything on behalf of the business. All of the accounts are frozen, and your staff, they're legally powerless. They don't know what to do. Bookkeepers, CPAs, their hands are tied. Nobody has access to anything. And the most common problem is lack of authority. Banks don't care that your spouse knows about the business or that it's your spouse and you trust them. There is no presumption under the laws that you trust your spouse and that you would want them to have access to your business information. And this is not just about death, it's also in case of incapacity. If you become sick or incapacitated, will your spouse be able to maintain your business accounts? They're not listed as a signer on any accounts. So let's walk through what causes these breakdowns. So in Colorado, as a business owner, you can either be an LLC or a corporation. And what that does is it basically protects you from any personal liability. The reason why you set up the underlying legal structure is that you don't want your business liability to trickle into your personal assets and vice versa. So you want to make sure that you're limiting liability for the business activities. So ideally you will have either bylaws or an operating agreement for your business that kind of designates who has legal authority over the business. And it's all just you, the owner, during life. But what happens if the owner becomes incapacitated and they don't have an estate plan? Then nobody has access to anything. Again, even a spouse or your best friend or somebody that you trust. So in case of incapacity, you need a power of attorney, and that is a legal document that basically says that if you become incapacitated, you give the authority to manage your legal and financial matters to somebody. It can be your spouse, it could be your friend, your partner, whoever you trust. That way, at least if you're unavailable for a few days, weeks, or months, that person can temporarily take over. The next step is what happens if you pass away. And the best way to protect your business against probate implications and all of the delays and costs that come with that is to place your business into your revocable living trust. What a trust does is that it lets all of the assets that you put into it avoid probate court, including your business. That means that your successor trustee in the trust, like your spouse or somebody else that you appoint, will have access to everything in your business right away. They wouldn't have to go through probate, and they will be able to access all of the accounts, run payroll, hire a successor, or liquidate the company before any other sort of liabilities arise. What actually protects your business is not just one document. You have to realize that there's also contracts and vendor agreements that you may have, and if you're unavailable or incapacitated, the default clauses may be triggered. So it's essential to make sure that you have a succession plan or an estate plan for your business. The law does not protect you in any way if you don't plan. It's all in your hands to plan for your business now. So this gives you something useful, I hope, to think about, because building a business takes vision, but also making sure that it passes on as conscious legacy takes a lot of planning and consideration. We'll be covering more topics like this in our other videos, so subscribe to make sure you don't miss anything. And if you've enjoyed this video, please like it and leave us a comment.